Thank you. My name is Turlough Stone. I'm a barrister at Quadrant Chambers. I have been practicing in commercial and chancery law since 2007. The title of this QBiT talk is How to Obtain an Asset Preservation Order. It's a sad fact of litigation that a number of good claims and good judgments are frustrated by dishonest defendants who put beyond the reach of the court property or evidence or assets. The court is of course alert to this problem and over the years has developed a formidable arsenal of weapons that can be deployed to preclude such unscrupulous conduct or to minimise its consequences. The minds of most practitioners will turn naturally to the court's nuclear options of freezing injunctions and search orders. However, those are often difficult to obtain and they are often inappropriate in the circumstances of a particular case. Moreover, they are time-consuming, expensive, and carry with them considerable litigation risk for both lawyers and for clients. So if a client comes to you concerned that a party against whom they are bringing or intending to bring a claim may put assets beyond reach or may destroy evidence or property, are there any other options which are less nuclear, less draconian, and less problematic? Well, yes, there are. And I'm going to be talking to you about one of them today, namely an order under CPR Rule 25.11C1, which doesn't exactly trip off the tongue. I should explain why you might want to consider it. Broadly, there are three reasons. The first is that the definition of relevant property for the purpose of the rule, which is contained in CPR 25.2, is very wide. The second reason why an asset preservation order can be useful is that because the rule is widely framed, it can be deployed flexibly to suit a wide range of circumstances. The third reason why you might want an order is that it can be easily combined with other remedies and other orders. The next question is, what tests does the court apply when deciding whether to grant one? Orders under CPR Rule 25.11C1 are discretionary, and the courts will typically apply the principles that are set out in American Cyanamid when they are determining whether or not to grant an application. The court will ask itself four questions. First, is there a serious issue to be tried? Second, would damages be an adequate remedy for the applicant? If not, this is the third point, would the applicant's cross-undertaking in damages be sufficient to protect the respondent in the event that, at trial, the court concludes that the order ought not to have been made? Fourth and finally, and this really is the basis on which most applications are determined, where does the balance of convenience lie? Where an order extends to a requirement to deliver up or permits an applicant to enter onto property, the court won't apply the American Cyanamid principles, but will instead apply the rather more onerous tests that are relevant to applications for search orders or delivery up orders. And that's quite important. It may make it harder to get an order if you combine it with other relief. And so therefore you need to think very carefully when you're going for an asset preservation order whether you in fact do need to enter onto land or whether you do require delivery up when you are applying. That brings me to the process of applying. You will need as a minimum 4 documents. The first is an application notice in form N244, or if you're applying in the commercial court, form N244CC. Second, you will need evidence in support by way of a witness statement or an affidavit. If any part of the relief that you're seeking involves entry onto land, however, the witness evidence must be in the form of an affidavit. Whatever form it takes, it should comply with the requirements of Practice Direction 32 and the relevant court guide for the court in which you are issuing. The witness statement should address the relevant test or tests, questions such as urgency, and also address the adequacy of the cross-undertaking in damages which your client will be required to provide. And invariably, the court will require such cross-undertaking as the price to be paid for the grant of an order. Third, you will need a draft order, As to that, two brief points can be made. The first is that when drafting, precision is the key. You must specify as exactly as you can what asset it is that you want to have preserved. Broad categories of asset simply will not cut it with the court, it will be unacceptable. The second point is that if you are seeking relief that's analogous to a search order, you might wish to consider using the standard form of order annexed to Practice Direction 25A, suitably modified. If you modify that document, and this is a pro tip, which applies to any application where you are using a standard form, when you make a modification, leave it in track changes in the version that you send to the judge. This allows the judge to readily identify what the changes are, and means that you, when you're addressing the court about the form of the order, don't overlook any changes. Because if you modify a standard form of document, you have to both explain and justify the modifications to the court. Fourth, you will need a skeleton argument. You can apply pre-action, or after a claim has been issued, or indeed post-judgment. If you're applying pre-action, you should also produce a draft claim form and ideally draft particulars of claim for service with the application notice. Pre-action applications should be made to a High Court judge. If proceedings are already on foot, you should apply in the court in which the claim form was issued. Post-judgment, you can apply to a High Court judge or to a master in either the King's Bench Division or the Chancery Division. The matter is likely to be urgent and require expedition. If it is, you will need to explain in your witness evidence and in your skeleton argument why it is urgent. The urgency might be such that it warrants going without notice. That depends on the particular circumstances of the case. If you have credible evidence that the respondent is sufficiently unscrupulous that they are likely, if notified of the hearing, to move quickly to dissipate assets, destroy evidence, or move property out of the reach of the court, then you'll be fully justified in going without notice. If the evidence of impropriety is a little less clear-cut, you might consider going on short notice. If you go without notice, both you as lawyers and your clients will be subject to a duty of full and frank disclosure. That is an onerous duty. If there is any evidence or if there are any matters that point against the making of an order, that needs to be dealt with clearly in the witness evidence. If there are any legal arguments that could be raised against the making of an order, that has to be dealt with in the skeleton argument. When you get to the hearing, you have to produce a detailed note of the hearing. Please make sure that one of your team has the capacity and the ability to take such a detailed note. The note is a procedural requirement. It is policed strictly by the court. And if you fail to produce an adequate note, all you are doing is effectively giving the other side, or worse, the judge, grounds for complaint at the return date. The note has to be served on the respondent if or when you get the order, along with the application notice, the supporting evidence, the claim form, and the skeleton argument. And that, in a nutshell, is how you obtain an assets preservation order. Thank you.